Everybody, welcome back from the coffee break. Welcome to Georgetown Law. Welcome to the Georgetown Capital Campus. It's always a pleasure to host you here for what I think is already becoming really one of the most important conferences in the antitrust and political economy and competition policy conference circle. It's a very unique place that brings people from all over the world, and we're always very happy to host everybody here at Georgetown. So Alyssa mentioned in her initial remarks about the change of the political economy framework, the change of the trade framework. You know, there used to be a professor here, Steve Salop, a titan of the field, who used to say, you know, antitrust and trade are the same policies, they're just separated by a border. And so as trade changes in the world, antitrust has to change in the world as well. And so I'm very happy to actually host this panel, International Developments, not only to talk about what's happening outside of the traditional UK, US framework, because there's a lot of exciting things happening, but also because we have people from places around the world talking about what's happening around the world. You know? And I think in these types of conversations, having institutional knowledge is always very important, and having a good understanding of what's happening on the ground is always very important. So starting with disclosures, including my own, I'm Filippo Lancieri. I'm an associate professor of law here at Georgetown. And I received a grant from CADE, a Brussels think tank, 3 years ago to work on access to data for researchers and for companies in the DMA and DSA framework. The way that we run this panel, we're going to start with Gunn from Berkeley, giving us a small overview of what he's doing, a lot of research trying to map exactly where the developments are around the world. Then we're going to start going down the table and to understand, like, try to pinpoint commonalities and differences between the different regimes. We hope to have a very engaging conversation, and I want everybody ready to jump in with questions and interventions as early as you can. So that's it. Gunn, I'll give you the floor, and please give us a... Yeah.
Hello, everyone. My name is Gunn. I'm a JSD candidate at UC Berkeley. So I have nothing to disclose. Well, I'll start here. Do I need to go up to the panel? No. Okay. All right. I'll just sit here if it's okay. Yeah. So I'll just start with an overview, and thank you, Filippo, for the starting the session. Like he said, I'm studying something I call the diffusion of digital competition regulations, or the diffusion of DMA-like laws around the globe. And I know it's a increasingly topic that everyone is interested in. And so I have two slides, but the first picture is a big snapshot of what's going on here. And as we can see, we have current enforced law, of course, the DMA, and we will learn about it more in the next session. But then we also have the UK, Japan, Germany that is ongoing. Then the second grouping of the countries is the draft laws, right? We have active drafts that is just going through public consultation, await for being enforced, for example, like Brazil that we'll hear more about, and then Australia. And then there's also draft that has been pushed out, but it has been withdrawn. So I considered the US several drafts that was put out, but was not successfully passed. India and South Korea, where we have expert here, will talk more about it. And then we also have reports. For me, in my research, I try to simplify and categorize stuff. And for me, South Africa falls under this. Now, if you see in the picture, there's some dark gray countries that I made some notes on it. So there's a lot of maps about this topic, and some maps, and I'm referring to a FT article that was referring to a CEPA article about trying to map all around the world. So they have a bigger scope than me. And the dark gray areas are the countries that it seems like there's some developments to. Maybe they pass a law, maybe they are thinking about it, but because of the categorization, so I haven't focused on it, I haven't checked it myself, so I'll just note it. For example, I come from Thailand. We have a draft law, but now it's more of withdrawn pending further review. So this is the big picture. And then jumping towards the second picture, I think I'll start with, this is where I'm trying to map out what has we been through as we think about DMA-like laws. So basically, I think, as you can see there, this is a very simplified timeline. I left out a lot of things, but I hope I can push some information to be a foundation for this discussion. first is it's been a long journey. So since the 2020s, I think we have seen expert reports from the UK, EU, the US Stigler report, which state like the debates on this and really happened in the 2020s. And then I think the jurisdictions around the world really picked up in the 2021 and 2022. And I just really want to note that, as you can see in the line there, I was studying. Let me walk back a bit. My apologies. So I tried to collect information from 5 steps. So it's announcement, whether it's like agencies or presidents or politicians who announce whether they want to take on a DMA-like law or digital regulation. And then the second step is the expert report. So it's very interesting how whenever any countries want to take on this initiative, they'll establish a committee. The third one is draft regulations. And then the fourth one is public consultation and then enforcement. So I try to categorize, simplify stuff here. As you can see, the first point I want to point out is that in around 2021, it's very interesting because there seems to be an alignment in major jurisdiction. EU was thinking about the DMA, drafting the DMA. In US, there were the bills in Congress. And actually in China, there was like a super platform guidelines which popped up. And as you can see, some of the countries who were doing expert report or reviewing countries around the world were saying that like, oh, there's some alignment, there's some development. Of course, the US case and even the China case, those guidelines or those laws didn't materialize, but the world moved on. And as you can see in 2024, I think every country kind of had their own thing going on. And a big part when I present my research is like, why is the quick adoption? What's so special about it? Of course, we talked about the Brussels effects, and I won't go into details, but I think there are other reasons. For example, what is about the template of the DMA, which offers kind of a detailed but adaptable template. So jurisdiction was taking on and kind of customizing it on their own. There were some of the appeals of the objectives, the contestability and fairness, which resonate with a lot of jurisdictions. And there was an appeal of self-executing rules, right? If we follow DMA in the beginning, that was the main appeal. And to be frank, there was not much a competing template at the time. When there was the DMA and the UK, the Japanese was just still budding up. But now for the myth of like the self-executing myth or a belief and the template, competing template, I think we're seeing more that is coming up. I will just talk a bit more about this graph, and I will end very soon. But basically, for me, in my research, I think the first top 4 country is, I use the EU DMA as a baseline model. So, of course, we have the core platform service and the obligations that they've set out in the DMA. And of course, I categorize the UK model, the Japan model, or the Australian model as a more narrow approach. So, of course, they have their own destination rules and their own scopes of the sections. And Australia is a unique jurisdiction who took on a 5-year-long research project at producing expert report, conducting market studies. And then for the bottom 3-4 country, I think I categorize them as taking a more broader approach. And our panels will correct me how wrong I am, but they took on a more broader multi-sector similar to the European Union approach. And interestingly, these jurisdiction has withdrawn or has faced some resistance, and some of them are rethinking their laws. Lastly, I'll just say this. So we talked about, in the debates, we will talk about how what's the best model for each country. I want to shift the attention to this point. I think I'm interested in customization trends, what the trends of countries have been adopting. I argue that there's a lower destination threshold. So everyone, of course, has a smaller market than the EU. So to capture the gatekeeper, they're lowering down their thresholds. We see that across the board. There's some selective obligations. So countries are talking to each other and see which obligation we choose. Some people copy the DMA, some people take some out. And then some people are very clear, for example, that they want to tackle certain jurisdiction. Their expert reports show the market study of smartphones, the sectors. So it was very clear from the start of the expert report and what they do and where the law was going. But these customizations really head to what I think is our discussion here about the political economy. So the lines you draw in the design choice you make will kind of create the correlation in the legislative process. We know that in the European Union, we draw a line about the gatekeepers, and then there's supporters of the DMA, who is also very wide, civil society, startups. But in other countries, the choice they make may draw different lines, and we've been having discussion about what the role of startups in each country is, where do they stand. And the second one that I just want to point out is like the international engagement. So because I looked at a public consultation process, we see diverse stakeholders participating, domestic, international. And I think it was in the Brazilian case where I think it was innovation of how the report mapped who was the stakeholders, and there was more international stakeholder who participate in the public consultation more than Brazilian companies. And we see different transparency, different way of presenting information about that. So I'll stop here first. I have a little bit more on the second phase, the US, but I think I'll leave it to the next round.
That's perfect. Thank you. I think when you're preparing this panel, it was a very interesting conversation to just understand how much are the DMA and the UK, the MCCA model, really like the thresholds under which countries are building, how much are they adapting, and when they're adapting, what are they adapting? What is the focus of the adaptation, right? What are the local, national drivers that lead to this kind of transitions? So now I'll pass the word to Vikas from BML Munjal University. So Vikas, how do you see the separation? Do you think from the Indian perspective has been active, do you see the separation between the DMCA and the DMA models as like good ways of thinking about these regimes? And then in particular, how has competition enforcement continued in parallel? And what are the local drivers? Like, what are the markets that are the most concerned, the most concentrated? And who are the players pushing for these national reforms at the local level? Great to hear any thoughts here.
Yeah, thank you, Filippo. Thank you for having me here. 2 disclosures. First, no conflicts of interest. Second, I'm super jet lagged. I'll try to say something meaningful. Okay. On that note, I'll take up the first question. Like, we have 2 models as of now, DMA, DMCC. So basically, these 2 models, they are trying to approach the same mischief. The market is concentrated. These gatekeepers, they have market power in their specific context. The context is important, right? Economies of scale, economies of scope, the markets are tippy. And these platforms are big, and they become entry points, the bottleneck points for both business users and for consumers. Okay, you need to do something about it. There is a kind of market failure. How you do is becomes very important. Now, the DMA, Article 3.1 of the DMA defines, what the problem is, and then 3.2 has the quantitative thresholds, and then comes the qualitative threshold. So basically, it's the designation thing. Now, when you look at the DMCC, it is approaching the same kind of evil. However, the designation is important because at the stage of designation, the power has been given to the regulator to first look at the qualitative features and the quantitative features in conjunctions. So as a regulator, I have to identify economies of scale, economies of scope, network effects. I have to prove my case. I have to build my case. Now, this is a problem for developing countries and in general as well, because we don't have the resources. Remember why we enacted an ex-ante regulation, because the markets are tippy. We can't be sitting on it for a long time, right? So while you designate someone, the horses have already bolted if you get into the qualitative criteria. And second, it's enormously expensive, especially for resource-constrained regulators to prove their cases, right? Because the burden of proof is on you. And only then it goes on to the defendant. That's the first thing. The second thing is that once you have identified gatekeepers, then you also need to identify the kind of conduct that they need to tweak, they need to adhere to. Now, DMA is a set of rules, not principles, right? Rules versus principles, we know the trade-offs very well. So DMA just tells you that, look, if you are a gatekeeper, you have to do this, and you do not have to do this. Article 6, 7, the conduct requirements. But when it comes to DMCC says that, okay, no, you have to make rules. You have to lay down the criteria for each gatekeeper separately. Now, once again, it's super resource intensive for a country like India. Of course, we are 4th largest economy, but the regulatory system is not so mature. The institutions are very important, and institutional reality dictates that be mindful of the reality. So what this means that we opted for the DMA kind of framework with minor tweaks. Now, why this is a problem in general is that eventually the idea is to pull the gatekeepers, those who have market power, to the table, to the negotiation table, so that they can mind their business, mind their conduct. These negotiations, however, happen in the shadow of law. If you have a law which can always be questioned, which can be dragged into the judicial system forever, then I'm afraid that it does not cast strong shadow. You can have negotiations there. So that's why I'm a bit skeptical about the DMCC version. I'm sorry, the Brazilians have oscillated towards the DMCC from the DMA, but I'm sure you have your own reasons. Perhaps you will throw light on that. The second part is, what are the factors driving the discussion on ex-ante regulation in India? So India, I think the need and the demand was quite homegrown. We had startups, they were at the receiving end of self-preferencing practices, other kind of practices, deplatformation practices. And the Competition Commission of India, I worked with the Competition Commission of India. It's a strong body. Of course, it does not have the kind of resources that requires you to enforce competition law in digital market, but it tried its best with the ex post rule. It realized that the tool was blunt. It was not, first, it was not quick. Second, in some cases, the defendant was just not dominant in the ex post sense. So they could do nothing. They approached the government and said that, look, give us a new tool. So this was the demand, homegrown demand, which propelled the government to come up with the committee, and the committee suggested something on the lines of digital competition bill.
And just so, what were the most affected sectors? Like, what exactly were like? Is it like, think about the big gatekeepers, no, Amazon, Google, well, like, was it like mostly in like the e-commerce market? Was it in the app store? So like, what this enforcement that you think failed in what areas in particular?
It was everywhere. Look, we are strong digital market. So we had problems with Google self-preferencing. We had problems with pre-installation of the Google suite. We had problems with the ride-hailing services, Uber. We have a competitor to Uber, Ola. So it's a duopoly, right? We had problems with their pricing practices. We have problem with most favored nation clauses. And then I have a story like Amazon self-preferencing. It came up with own white label brand of shirts, and it threw the main, the business it was hosting on its first page to page number 3 after having copied its product. But the Competition Commission of India took a suo motu cognizance, but could not proceed with the case because Amazon in India is not dominant, unlike the European Union. Because we have, again, a local competitor to Amazon, which is Flipkart. So what do? We do nothing. So Competition Commission of India could not proceed ahead with the case. So just like Europe, in India, we have problems. We have faced problems in almost every vertical of the digital market.
Thank you. That's fascinating. I'll move now to Camila. Camila is both a commissioner at CADE, the Brazilian Competition Authority, and a professor of economics at one of the best universities in Brazil. So Camila, tell us a little bit about this Brazilian new model, right? That's emerging after a lot of discussion. I think Gunn presented well, and you've been participating in the debate. So how do you see it connecting to the international models? And what were the local drivers that are kind of pushing this process forward or backwards? We're going to talk more about it later.
Thank you. Thank you so much, Filippo, for the invitation. It's a huge pleasure to be here. By way of disclosure, well, I am now a commissioner at CADE, so no disclosure by now. And before, I have not acted as an expert in digital cases and have not been engaged in any research funded by digital companies or by related institutes, so no disclosure to get. Well, in Brazil, we are still at the legislative stage, and the executive has sent the bill for 2006-7525 to Congress. And what the bill does is amend Brazil's competition law to create a digital market superintendents within CADE, the Brazilian authority, antitrust authority. And the bill explicitly states that CADE's actions in digital market are guided by 3 objectives. So we are putting in force in reducing barriers to entry, protecting the competitive process, and promoting freedom of choice. So different objectives from the antitrust law. And it also sets out a formal process to designate systemically relevant digital, why we are calling gatekeepers, difficult way to call gatekeepers, but we are going to do that, and to impose special obligations on those designated firms. So yes, we are going into kind of a hybrid model. It's not a straightforward DMA transplant, and it's not a pure UK-style supervisory regime either. It, of course, aligns with DMA in the basic diagnosis that in digital ecosystem, case-by-case enforcement alone can be structurally late, all the things that we already know, and that logic sits at the core of the early intellectual foundations for ex-ante digital regimes, including, of course, the Furman Review and the Special Advisors Report to the European Commission, of course. And at the same time, the Brazilian bill learns toward the DMCC philosophy, as it was mentioned before. Instead, in a way of its operational posture. So instead of a fully standardized rulebook, it emphasizes designation plus calibration. It combines quantitative triggers with a qualitative assessment of ecosystem power and enables obligations that can be tailored to competitive bottlenecks at issue. So in other words, it moves towards a more administrative and iterative model of competition governance, closer to the UK's idea of addressing platform power through an ongoing supervisory relationship rather than a single shot infringement model. So I believe that the headline is that Brazil is legislating an institutional bridge, an ex-ante layer inside the competition authority, designed to run in parallel with classic antitrust, aiming to make enforcement more forward-looking, where market dynamics are path-dependent and remedies need to be spiked before the market locks in. Yeah.
Thank you. And just building on that, so one of the things I find fascinating, I'm Brazilian, so full disclosure on that part. But when I work in private practice in Brazil, CADE runs a lot of monopolization cases, right? So like when I worked for like 5 years as a lawyer, I think I worked in like 15 investigations. I'm not joking. And then you look at the context of the US, or the US hasn't run a Section 2 case other than 5 years ago for like 40 years, basically, other than Microsoft. It's fascinating to see this theoretical discussion of like, how do you see the competition policy moving together with the regulation policy, really in a context where this is actually happening on the ground. And so from your experience with like, what are the sectors that CADE is the most active? And it has actually been issuing preliminary injunctions. Everything that people ask, that want competition authorities to do more, CADE has actually been doing for some time now. Do you think there is this diagnosis that this system has ultimately not delivered on the ground, and this triggered this reaction to the more DMA style or the MCC style system, or how did it come about?
I think that the most reason for us to choose for the UK model is to be able to prioritize. So I think that on the key topics, the Brazilian digital case and remedy negotiations have clustered around issues that look very familiar internationally, especially in app stores and mobile ecosystems. And the recurring themes include non-discrimination and ranking, and including how visibility and prioritization are shaped inside platforms, more transparency for business user about how offers are displayed and or prioritized, limits or certain form of self-preference and time, and in some instance, measures aimed at reducing switching frictions or enabling competing technical solution to operate on fair terms. Well, I don't know if it answer your questions.
Yeah, but I feel like it's this notion that, like, all these attempts ultimately failed in delivering, and this was a trigger for the regulation, or not yet. It's just too early to have an assessment. Because I think part of this big discussion is like, competition policy could not really deliver on the ground. We heard this from different people, and this is what motivating the switch. I wonder if, like, how do you see that after years of enforcement? Now, CADE has been running investigations for many years now and actually adopting remedies.
Yeah, for sure, the remedies are important and to be adopted, but we are still in the same page that we need an ex-ante complementary to do the right job as we want to, because the investigations and the remedies are slow and not in the path and the speed that it should be. And also, we had an early, very recent experience of making a settlement in the Apple case, for example, and we are certainly sure that we're not able to replicate this for all the cases, because it's quite impossible. It's a lot of effort, so ex-ante structure is necessary to deal with that.
Very interesting. It's interesting to see the resources always coming about as the triggers here, right? And so we move now to Sangyun, who is based at Kyoto University and is from South Korea. So it's like a great merge between what's happening in Korea and in Japan. So what's happening, is your view, on the ground in terms of the proposed changes, and what are the key triggers and local drivers that are impacting this regulatory discussions?
Thank you, Filippo. Thank you for having me, and I'm really thrilled to share the Japan's and Korea's situations before you. And when it comes to digital platform regulation, first I want to make it clear that it's my textbook perception, though competition regulation can be justified when the market mechanism doesn't work and the competition law doesn't work. And then so as a complementary tool, competition regulation can be introduced. That's my basic perception. But Korea and Japan situation, from my perspective, is quite different. But nevertheless, those two jurisdictions, well, in the early 2020, tried to follow European Union's DMA initiative. So it was really, from my perspective, it was really problematic because, well, okay, let's say, it depends on your perspective, whether the market works or not. So let's just say the Korean market and Japanese market, those two markets are also suffering the same concerns and problems. But I would like to share this fact that Korean and Japanese competition rules have different, very distinct tool sets, which is called unfair trading practices. It historically originated from the unfair method of competition of the United States Fair Trading. Section 5, right? But it is really used in a really different way. So the KEFTC and JEFTC can sanction any practices, technically any practices, abuse without dominance, and then, well, exclusive dealing without market power. So they already have these tools. So they have used these tools to sanction many practices, and then by large or powerful firms. So, but for some reasons, I would say that in early 2020, the policymakers may have thought that, well, there is a global trend that we need ex-ante regulations. So we don't want to lag behind, and we don't need to be left behind. So we also need ex-ante regulation. So, of course, I'm not sticking up for, well, deregulation stories or we need a free market. But in this sense, the whole story was really
but how do you think they differ on the ground? Try to be a bit more specific. What investigations they were running, and how do you think that? Because, for example, Korea has a lot of Korean-grown platforms, right? That make this. So to explain us a little bit more of the local, like very specific context.
The market realities.
Yeah.
Well, I personally believe that Korean market is quite competitive. For example, there was a case about self-preferencing, and then it was out right after the Google Shopping decision was out. So which means that the KFTC followed the European Commission's approach. But the thing is that the case name was not Google Shopping; it was Naver Shopping, which means that Naver was dominant company in Korea. It was fighting against Google. But anyways, the KFTC wanted to make a okay, no one get offended. Okay, the KFTC wanted to create a Google Shopping case, like Google-like shopping case, or Google Shopping-like case. So it created Naver Shopping case. So it promoted a lot. Okay, we also have self-preferencing case. So and many scholars were really upset about the outcomes because sanctioning some company, well, can be a tool to promote enforcers' capability. So anyways, yeah, let's put this issue aside. But anyways, yeah, okay. I'm sorry if I feel also really super jet lag as well. So we call it this a jet lag. So
no, this is great. This is great. I
I
think it's very interesting.
Yeah, don't get surprised if I suddenly start speaking in Korean, but just let me know. Anyways, yes, the market realities. Yeah, this shows that the Korean market is quite competitive. And then, unfortunately, after this sanction, and the neighbor started to lose their market share, and the Google is now dominant. So it's a ridiculous situation. So, anyways, yeah, and then the e-commerce market. There is a company called Coupang, and it is also fighting against Amazon. Actually, Amazon failed in Korean market, and then we are using a different chatting app, and which is called Kakao, and it's a really super dominant app. So yeah,
it's interesting to see that at least in some places this enforcement changed market realities, maybe not exactly in the direction that makes some markets more competitive in some ways. So let's move a little bit more to the political economy behind it. I think is one of the triggers of this panel as well, right? So Gunn, you mentioned that you're integrating kind of like this local pressures and the strategies of gatekeepers fighting back. Have you seen are they really always the same? How do they differ? What is the importance of like local pressure groups? What thoughts do you have on that?
Yeah, so I think I'm very interested in you mentioned like how the coalition forms in like pushing for the laws, right? I think for me it's about how so for me in the DMA I'll use the DMA as like a baseline point. I think it's very clear that the gatekeepers, and although the gatekeepers on the one side and then the civil society and on the other side, but then in other countries, I think what I've been observing from like these public consultation is that it doesn't the pros and cons shifts into different lines. But just for example, and please correct me in each jurisdiction, like for India, right? Their report was very interesting for me. So when the report came out, they had like a summary of comments that they gave out, and they list two groups of people: the big techs, and they were all against the law, with some people saying like yes, but with some nuance. But it's very interesting how the India report framed that, because of course, when you submit something, it's probably like a lot of reasons, very long, but they summarize it in one box. And then the other box was the associations. So every association was like support of like this law, like the trade association, travel association, like the SME. So it's like the domestic association representing like the smaller business side. But then when the report came out, I think it went into the wild. And then I think there were debates about the startup community that we were talking. Vikas, you can explain more, but the startups kind of broke into two groups, and there were debates on this. So I guess for me, to just summarize this part is that I think I see some groups that doesn't fall along the line, and they kind of have some new debates that we don't see in what we are familiar with. So that's one point that is interesting for me in the India case. And for example, South Korea, like you said, there's a lot of Korean text there, and I think it's only one of the few jurisdiction that maybe if we set a gatekeeper rule, there'll be a lot of Korean text in there. And for example, when I studied the Korean case, the New York Times was very clear that it was the local platform that led the charge on pushing back against this, and was quite successfully. And there were some dynamics about like elections is coming up, and there was like the president had a position on tackling being tougher on big tech in the South Korean case. But then there's also reports on like in the New York Times report saying that like the smaller business was very afraid of passing the costs down from the gatekeepers. So these are very hard to capture, but it's in reports and it's in how each jurisdiction frames their kind of like public consultation. Yeah. And just one last point. I think because Australia is also an interesting point because they've been doing public consultation for the past 5 years on each market. I highly recommend their last report, March 2025, I think. And they try to weave in the narratives about, we have all these like smaller techs who's trying to contribute to the discussion and how they found that there's change in market realities. So I think the more, I think newer reports and newer public consultation are being more robust. And I think we can learn a lot from each other, and we're seeing a lot of interesting dynamic there.
Because jump in, so to tell us what were the pressure points in India, and in particular, what strategies were the big tech companies using for lobbying and to try to prevent, how is this happening on the ground, and what has been the role of civil society there?
Yeah, that's a very interesting part. Look, with regulation, a regulation happens only when there is a demand for it, right? If there is no demand for regulation, policymakers, the legislator will never enact because there is cost. Now, when you look at India, as I said, that the demand for an ex-ante regulation was homegrown. How was it tackled? So one criticism of our DMA kind of bill was that the thresholds were very low. Now, this is something which one needs to take very positively. Even pro-regulation people like I am, we can discuss it. We can peg it against the entire economy or digital economy. That's a valid criticism. However, the criticism is general in nature that it's going to chill investment and innovation. Now, this is something very serious. How it does it, nobody knows, right? So entire startup community got divided into two parts. First part, it was supporting legislation. The second part, which was against legislation. And that was the main fear, that the thresholds are very low, it's going to chill innovation. But beyond that, there is no greater, deeper discussion as to how it happens. And so far as the second community is concerned, it is again very interesting. Like most of them are dependent upon these gatekeepers platforms, and their interaction is not one-off. It's a repeated interaction. So you don't want to sue the platform on which you are dependent and also go to them to use them, right? So it's sort of like an arm twisting tactic, like you support us and we are going to behave in a particular way.
Interesting. Howard Chelansky, another professor here, once gave a keynote in Brazil, and he said, the definition of an ecosystem is that you can bring your complementers to your defense when you're under attack. I think this connects tomorrow to the debate that Fiona and Ioannis will have as one of the best way to define an ecosystem in and of itself. And so tell us a little bit more about the role of civil society there as well, right? Because in a way, you would expect that, how is the academic community reacting and the other NGOs world, and how is this connecting to the debate or actually framing the conversation in any way? So how do you see that?
No, this is the dirty part. Look, economics is one thing, but once in a while, we academics have to, don the hat of activist as well, because there is a huge money and most of the think tanks are compromised, right? I say this not because I feel like, but because of the reports they came up with. The methodology was questionable. I wrote on it, right? And they were cross-citing each other. There is little evidence aside from general comments. And this is how they create the halo of academic literature. But it is not there's nothing academic about it. So, we are up against huge forces. And there are small consultancies, small think tanks, which are promoting the interest of consumers, but they do not have the kind of say that these big consultancies have. So that's why, the academic community, Ascola, has a greater role to play in developing countries and all the other jurisdictions which are in the process of enacting ex-ante regulation.
Interesting, fascinating. So Camila, tell us a little bit more about Brazil, right? So how is why now, you think? Why is this coming about now? What were the main triggers, and how do you see the same dynamics, of like Brazilian NGOs engaging the academic community and the pressures that CADE is receiving from different dimensions into trying to pass this bill and make it into reality?
Yeah, I think that we're going to similar challenges. I mean, you can see few recurring moves. So we do have the first move that is gender framing, like arguments that the existing framework is sufficient and that ex-ante layer could chill innovation or raise compliance cost. We do have also the procedure thickening, multiplying checkpoints, like impact studies, pilots, carve-outs, phased implementation. That may be defensible individually, but that cumulatively tend to stretch timelines and narrow obligations. And we do have a third way of doing there right now, this kind of forum shifting, like attempting to relabel the core discussion as telecom, consumer protection, data protection, or industrial policy, which can fragment coalitions and dilute the contestability objective. These are the possible strategies. At the legal constitutional point as well, pushing for highly formalistic triggers and constrained discretion, partly by invoking risks of overbreadth and capture. So these are hypotheses about incentives and tactics, not a claim that any single firm is doing all of them. It's also important to note that the public debate has not been one-sided. There are some multi-stakeholder internet governance bodies and digital rights civil society coalition have issued public notes broadly supportive of the proposal rationality, and even when they also call for improvements, of course, or more careful design. And finally, some actors have engaged less through explicit endorsement and more through convening and information dissemination, for example, in events on the regulatory agenda or through explanatory material that situates the view. I think that the dynamic so far is stretching the process and pressing for narrower, more litigation-proof obligations, and while a full delegitimization of the underlying premise appears harder in Brazil, given the persistent dependence complaints in ecosystem settings and also at the institutional credibility of CADE's techno tradition. But one thing that is important to mention, I think, is that in Brazil, we do need still we need development on academics works. They are independent and more connected academia, public and private, and I mean, in a way that we can have a more fruitful debate.
Yeah, no, for sure. I feel like people sometimes mixing this discussion, the separation between having actual engagement, which I think is mostly welcome, and having transparent, faithful interlocutors, right? I think that's a big difference that people try to merge together. It's totally normal for companies to push their message and try to operate and try to shape legislation. This is a bigger problem when they're doing this through incredibly shadowy ways, right? Someone reached out to me from one of the big techs and said, I do want to say something about the Brazilian DMA. We don't have to pay you directly. We can pay you through an association, so you don't need to disclose. I'm not joking. This happened a month and a half ago. And I was like, it's not exactly how we should do things, and it's actually pretty bad. But I feel like seeing these strategies play out in different parts of the world and seeing them repeating themselves, I think makes discussions that we have here around disclosure, transparency, even more important. So I don't know if you want to add anything or yeah. No, okay. So Sangyun, tell us a little bit more about these dynamics there in Korea and Japan, because I think there the dynamics are very different in many ways. And I don't know if the countries are even more exposed to this turn towards gunboat diplomacy. Countries that are so dependent on the US on like security and trade. How has this framed the conversations with the different windows that we had over time? If you go back to Gunn's message, it's interesting that they kind of all dropping out more recently.
So, including the US pressure? I mean, you mean that you just mentioned the gunboat?
Jump in and then we'll complement.
Well, Korea and Japan's situation, those two jurisdictions show really big differences. I mean, Korea, for example, Korea. Well, in the previous question, you asked me who were the or what were the main drivers of the platform regulations initiatives, and then I would answer to that question that yeah. Thank you. All right, thank you. Louder, okay. I would say, well, Google and Apple, for example. I mean, I heard that they lobbied a lot. They put a lot of energies into this issue to push back against the platform regulatory initiatives. But also, I want to also emphasize that in Korean or perhaps in many Asian countries, I mean, the bureaucrats are also heavily lobbying to get more regulations and regulated powers. And then it was really obvious in this case. I mean, Korea, for example, the KEFTC wanted to have a platform regulation, but KCC, the Korea Communication Authority, intervened, and this should be mine. And then they showed a really serious conflict between each other, and then because of the conflict, it ended up failure. The first attempt ended up in failure because of this internal conflict between the agencies. And then the second attempt, which modeled on DMA more closely, which was called a Competition Promotion Act. And then, this was much better. I mean, there were no conflicts between agencies, but it showed a really serious pushback from the public. It was really surprising that even startups in Korea really against government initiatives to protect them. It was very interesting because many businesses were really afraid of spending of government power. Because in Korean context, the government has already really strong power, and then the government doesn't want to lose their tight grip over private companies. So in that sense, the power game between the two different camps shaped the whole discussions in Korea. That's my perception. And for now, there is a company which is listed on New York stock market, but its main business area is Korea and then Taiwan, and it's also expanding its business to Japan. And then this company is sometimes called Amazon of Korea. Of course, it is competing with Amazon. But anyways, this is quite not very, it doesn't hold really international dominance. But anyways, it's a really powerful company in Korea. But the thing is that it recently it suffered, it experienced a really huge, massive data breach. And then there were many antitrust cases ongoing, but the public were really upset about the data leak and then what the KEFTC is doing. Oh, really? Because it's Data Protection Authority's job. But anyways, you have to do something against this company. And okay, let's do something. But the thing is that the Coupang, this company, went to the Trump administration and that this Korean government is treating me very harshly and in a really discriminatory way. And then I heard that today morning, and thanks to Hae-yoon, I learned that the Congress is now really, this Congress shows a really big interest in this case. So it is now triggering another gunboat, as you put it, pressure on the Korean platform regulatory discourse.
No, thank you. So I'll open for questions. Just ask one more quick question, then I open. I think there's a lot of people want to intervene. So we're very close to Congress, right? We can go down that road, I guess. And we had a congressional hearing, let's call it like this, a couple of months ago, I guess a month and a bit ago, with the usual, I mean, there was Roger Alford there, who was a serious guy, and then a lot of the usual cronies like the International Center for Law and Economics and people like that, basically just saying, like, this is all anti-American regulation. Do you agree? Like, is this your view on the ground that all these discussions are basically like, anti-American antitrust? Or is really like, this is really not a good way of framing it? And I think let's go down like this, start with Vikas, and then Gunn, you can give the opinion of the other jurisdictions that are not here.
Yeah, this is a very interesting question. Like, if you look at the ex post antitrust and its adoption, so many times it came as a package, part of the loan that developing countries would take from World Bank, International Monetary Fund, because it was in the interest of developed countries to have this level playing field. The developing countries, sometimes the criticism was it's like giving competition law to developing countries, like giving a silk tie to a poor man. But the economics justified it that, level playing field is good even for local groups, local startups, local companies, right? So you attain some kind of a scale and you're competing with big people on the level playing field, it is good. So that's why you saw massive adoption, but you cannot dismiss or discount the role that IMF and World Bank played. But when it comes to ex ante, there is nothing like that. There is no push coming from outside, rather there is a pull. Like, the trade negotiations, what happened in India, one of the theories is that it was pulled back, it was put on the ice because trade negotiations were going on. It was very difficult times, and India withdrew it just to give a sense that, look, we are not anti-big tech, we are not anti-America. Now, if I look at the Indian reality, as I have said, that certain Indian companies, certain Indian markets, they are not dominated by American big tech firms. Like, say, for example, e-commerce, it's a duopoly. Amazon is competing with Flipkart. They have the market share around 34, 33% each. Now, if we come up with something, the Indian startup would be, it would be applicable against the Indian startup as well. Likewise, ride-hailing services. Uber is not the dominant firm. Uber is competing with the local startup. So I think if you just scratch it, you see that, the law is applicable to everybody, including the Indian firms. It's just that the fear-mongering does not take that into account.
Thank you. Sangyun, what do you think? Do you think that the Korean and Japanese developments are anti-American antitrust or not?
No, not at all. And of course, I mean, in the previous question, I forgot to mention about Japan because I was too focused on Korea. I'm sorry, but Japan, I mean, it was a really interesting case. Japan, I mean, introduced already a Smartphone Act. Okay, I will and then Japan introduced a regulation. It was targeting Google and Apple, the Smartphone Act. But it was just surprising that the United States Trade Representative was not showed any objection to that. I heard that because app developers from the United States, they also lobbied a lot to the United States Trade Representative and the Japan's government, and then USTR realized that, oh my gosh, it may benefit another different side of United States firms. So it was really interesting. So lobby is not very simple. So that's what I want to add to the previous talk. And then when it comes to the anti-American argument, right? And I don't believe that. Well, I don't. United. Well, it's really okay to repeatedly mention the United States. What the Trump say? Of course, sorry, but yeah. Then a certain jurisdiction, I don't know. But anyways, the United States, the pressure, external pressure, is to my sense is based on the perception that the United States companies are treated in a really discriminatory way, right? And then, that may be the main the rationale of the anti-American argument. But I really don't agree with that perception because, for example, in Korea, the domestic firms are subject to much more heavier regulation. So I believe that the foreign companies active in Korea, they are benefiting from this asymmetric regulatory environment. And then also in Japan's context, well, I should be really careful because I'm still learning about the Japan's context. Well, but as I just mentioned earlier, Apple and the Smartphone Act is targeting Google and Apple, but it also benefits other United States app developers like Epic Games or Tinder. So I think it's a really misguided perception. I mean,
Camila, is anti-American antitrust in Brazil as well? Or?
No, for sure. And the clean way to say that it's the trigger is market power and gatekeeping function and not nationality. And if you look at the intellectual principle applied, it's not an American either. I mean, we are going to a very transnational debate, US scholarships and on platforms and market structure, US agents and state enforcement experience, global discussions in places like the OECD. So I think that the disagreement is mainly about institutional design and burden of intervention, and of course, not about targeting a country.
Thank you. Gunn, final thoughts, then we open up for questions. Yeah.
Yes. On this topic, I think I was trying to reconstruct my data from the U.S. side. So I think at the highest level, when the new administration came in, it came in with a presidential memorandum about defending American companies and innovator from overseas extortion. So there's this one guiding document that really put in the language of being a tax or being discriminated against U.S. Companies, right? And it's very interesting. With that as the highest level document, it trickled down from high level officials saying or talking about digital regulations being discriminatory. But then when you look at the writings, so one of the earlier reports was the USTR National Trade Estimate Report on foreign trade barriers. So it's an annual report that says what is a foreign trade barriers. And what is interesting is the report singled out the DMA and then South Korea case, even though they acknowledge that, the South Korean proposed law might be capturing some Korean companies, but we still think this is a foreign trade barriers. But interestingly, Japan and the UK case was not mentioned in that report. Maybe it's an uneven attention. Maybe it was very early, so we didn't have a very good understanding. So that was the early phase. Now the later stage is all these tariff deals they mentioned. I know that in other areas of digital regulations, there's these deals or commitment that two countries enter to each other, and they will have some commitments on data localization or digital tax. And of course, this is a game. Some people will say, we will have non-discriminatory commitments. But I don't see very clear evidence about how saying that digital regulations are being targeted on that level yet. But the last level is, I think now whenever there's some developments, commentaries will kind of point out to the risks of, you're going to invoke the anti-American pushback, and you need to be aware of investment, or not just competition, but the wider investment, which I think is a priority for a lot of countries in this new age of AI cloud investment. I'll leave it at that. Thank you.
Thank you. Why don't we get some questions from the room? I'm sure people want to interview. Let's get two, and then we can please hear you.
I think we're a little short on time, so we'll start here with Mike.
Yeah, Mike.
Hi, quick disclosure. Until a few weeks ago, I was an economist inside CMA, so I spent a lot of time thinking about digital regulation and digital antitrust. So my question is that, if we go back to 2019 and the Furman report and the Sigler report and the Kramer report and look at the ambition in those reports and look at where we are now, we're nowhere near dealing with that ambition. I'm really happy at one level that people think the DMCC approach is a good approach, but it does seem to take a long time and we're not actually getting very much out of it. So my question to the panel is, Do you think that the regulations in the various countries are actually going to move the dial? And if so, over what time period they are? And if you don't think they're going to move the dial, what should we be doing instead?
Okay, let's get one more and then we move back to the panel. And I think they had a hand here quite for a while. Oh, here. Xander, in front here.
The European Commission is the only and exclusive enforcer of the DMA in the European Union, and at the same time, the European Commission is also a highly political actor, right? So we end up having one desk where having to strike a trade deal with the Trump administration lands and enforcing the DMA against these companies that the administration seems protecting. Sort of they fall on the same desk, and sort of these trade-off concepts and trade-off problems have really sort of had an impact on DMA enforcement. And I was wondering to what extent you have made other experiences in enforcement authorities, how political they need to be in order to be able to have power and move the dial, but also how unpolitical they need to be and how independent they need to be from other political considerations in order to also move the dial forward. Thank you.
So, anyone wants to start? Camila, go ahead.
Starting from the end, I think that probably the way of doing that, well, thinking forward because we don't have the law yet, but it's thinking about cooperation. I mean, it's gonna be necessary to be a very intense cooperation between CADE and the other regulatory and other government institutions to get into all the details that we need to put the law forward. Yeah. And I mean, CADE is independent, so I do believe that this is going to work. But it's, well, we need to think it.
What about timelines? I think Mike's question. How imagine the law passes the next 6 months. How long would you expect to see actually any impact on the ground? You have the pen. It was a real question. Like, if someone there will have the pen to try to change market reality. So, like, what would be the best? I ask any of you. Like, imagine the regimes pass. What is the timeline? Yeah.
Well, it's going to be difficult, right? So there are certain realities which you need to keep in mind. First, you are trying to regulate people who have super deep pockets. They're going to challenge you at every stage, right? You have the judiciary, which is generalist in nature. Like, I come from a common law country. You can challenge the designation, you can challenge the fine, you can challenge the conducts, right? But there is no other way. That's the only way we can do it. It's going to take a lot of time, but I wish there was any other way to make sure that the markets are more efficient. Yeah. And the second thing is that, like, a competition culture takes some time to build, like in every country. Many a times, like, firms inadvertently flout the law. There is a competition compliance program. They get to know the precedents. They come up and people realize that, okay, this is something which is green, which is red. So, and in the specific context of ex ante, it's going to take even longer. I can't put a finger on a particular number, but you can see that from the experiences in the European Union, the DMA is going to be extremely, extremely difficult. And that brings to the final point of cooperation among agencies, which is very, very important. I was working on a project like the Uzbek government. They wanted to come up with ex-ante regulation. They have come up with ex-ante regulation. They just wanted to fine-tune it. So we were talking about the economics of ex-ante, like why it's important or not. And the guy who was there, he said that we understand the economics. We know it's super useful. It's important for our development. But the moment I go to regulate them, Meta says that, look, if you touch me, I'm going to leave your country. I'm telling you the reality, and they try to do it with some. Sorry. Yeah. Yeah. So and they try to do it with some African country as well. Now, imagine if there is a group of countries which comes together. I don't know how. It would be easy to, put your combined weight against these countries, and that's why, regional agreements are far more useful than ever before.
In a way, I think it's interesting to think of these processes of exportation as really building this coalition from the ground up rather than bottom down. I think answering a little bit Mike's question, for me, what I find fascinating is how much the DMA has actually changed the conversation in Europe from liability to remedies. Like if you see the Google shopping decision, it was like 220 something pages and the remedy is 2 pages. Now it's all about what's changing the reality on the ground. And so for me, that's a huge win if it's not really hasn't moved the needle. I think we have time for 2 more questions and then we close. So final here. I think there's one over there for Yunkin and one there in the back from Johannes. Yeah.
Thank you for the opportunity. So I'm a policy person and I'm very much interested in the geopolitical implications of the regulations. And I closely follow the South Korea's case. And I think it's really sad that all these regulatory efforts are just seen, especially by Washington, as like non-tariff trade barriers. And that's what we're experiencing today. And I was just curious that, let's say, for example, that all the legislations that's been presented, that's still under discussion or that's been passed or that's hanging, let's assume that that all passed. For example, the case of Korea, the online platform regulation passes the South Korea's National Assembly. Would it still give the fair antitrust in the digital market space is my question. So what I'm saying is it practically speaking, given the current political climate, possible to actually enforce and implement the bills that's been passed? And I was curious to hear your thoughts, depending upon the jurisdictions that you are comfortable speaking about, because for me, honestly, I can't possibly fathom South Korea, even though the bill passes, can it really enforce and fine Google or fine Meta or Coupang, for example, which is an American technology company, at the expense of upsetting Washington? So I would love to hear your thoughts on this. Thank you.
Thank you, Johannes, and then we will do a final round and then we
much interested in my personal views. So I'm very much interested in the countries that selected to move towards regulation, and some of them abandoned it. And but still, trying to find out why countries adopt regulation, that type of tool. So these countries seem to me pretty close to this, varieties of capitalism model of not the liberal market economy, but the coordinated market economy model, right? Where you could actually put Europe, the European Union in there. And I guess South Korea and Japan have been provided as examples of a coordinated market economy model, Asia style. So that could be one explanation. The second explanation could be public choice, in the sense of, and this is something that, the story is pretty old. I mean, the way, antitrust was pushed to Japan in the 1990s was basically coming out of the semiconductor industry in the US, that trying to, the US government, the Structural Impediment Initiative, trying to push for.
Let's be short, otherwise we're not going to finish here.
So the third possibility is the ideology, all right? So I don't know, New Brandeis, left-wing type of ideology might actually explain why you move towards regulation, or the opposite. I mean, you probably put forward left-wing ideology in Europe, in some other jurisdictions where probably you go for having more concentrated markets, let's say. I mean, I'm just, so what could be, from all these different explanations, the dominant one with regards to what motivates these countries to adopt this type of dysregulation, if you have done this type of thinking and analysis?
Thank you. So why don't we go down and start with you, Vikas, then. So first of all, what do you think is the main motivation in terms of these potential explanations? And second, how do you see the enforcement playing out in today's world of like a convoluted geopolitics, let's put it like this?
Here, Giannis, I'll try to answer your question, rather it's a thought, right? Based upon my experiences in India. Look, around 60s and 70s, the growth rate in India was just 2.3%, and it was pejoratively termed as the Hindu rate of growth. Come 1990s, globalization, we opened up our markets thanks to the pushes from outside, and it has worked wonders for us. We realized that capitalism, free markets, they unleash forces, and they need to be channelized through the institution of regulation to make sure that, they work towards the welfare of masses. And we have seen the results, like, we became the 4th largest economy. Now, this philosophy has worked wonders for us, and why do not we translate this into digital markets as well? We try doing it, but we are facing the pushback from the American government, right, from the US government. Now, this is the main reason why the bill has been stalled. And of course, you are pitted against countries which have, companies which have super deep pockets. But so far as the demand is concerned, I think it's super homegrown in my country.
Thank you. Sangyun, any ideas, thoughts on these final two questions?
Well, I would like to focus on Hyun's question, and that was really interesting. And but if I understand it correctly, your question is about whether Korea can enforce this regulation if it is passed. Well, I believe really I have no idea, but from an academic perspective, the right question, the question that I prefer to ask is that, well, there is an external pressure from the United States. And also, I believe the KFTC will enforce any rules on a non-discriminatory basis. But the thing is that as an academic, the question we have to ask is that whether how we can navigate to such a pressure to better serve the public interest. As I mentioned earlier, domestic firms are now subject to severe and more stricter regulations now. So I believe it might be Trump's pressure, maybe an opportunity for us to rethink about the current regulatory settings, because if we cannot make a level playing field by regulating Google and Apple or United States companies, then why don't we just deregulate the domestic regulations? Then I think that's the right question, I think, to ask in this context. So,
thank you, Camila. Final thoughts?
Yeah, sure. I'm going that line. I think that, well, I think I'm still very optimistic. We did an agreement with Apple in December, just the Professor Wright just mentioned earlier, and it was an ex post case. And we were able to do an agreement into the direction of loosening anti-steering, enabling or expanding alternative paying proceedings, adjusting terms that affect developers' ability to reach users. So I think that we are not in the position of not doing, and we are in the position of doing. And also, we do have in Brazil, we had the new child online protection framework, so it's not in the competition area. So the digital statute for children and adolescents, it's going to be implemented. It's already approved. And it includes age verification and so many things that are very necessary for updated rating and so many things necessary for the child protection in the digital environment. So I think that we are in a way of doing and not in a way of not doing.
Again, final thoughts.
Yes, I'll end it in an optimistic note too. As you can see in my research, there's countries that have already enforced the law, but there's a lot of countries that is trying to push the law into reality. And I think that's the first challenge of trying to push the law out, trying to have enough information to justify it or to confirm that we need the law or not. But I think if we move towards enforcing the law, I think we'll enter in a very interesting, proactive experimentalism phase. I don't think everyone will look like the DMA. Not every law won't look the same, but I think they can learn with each other and try to enforce the law as best as they can. And I think trying to create an ecosystem of enforcer who shares information, who has transparency, and they can learn from each other to tackle similar challenges or to learn how to find their own unique challenges would really help. So international coordination will be important. Transparency between enforcer agencies will be important. Sharing between academics will be important. And I think even from the enforcer side, how they design their governance system, their institution will also be the major point that we will need to discuss to achieve this.
Yeah, I think just a final, it's like ultimately gunboat diplomacy I always saw as a sign of weakness, not strength, right? It's much easier to control regulation, to control of the academic, and the time frames, the mindsets and all of that. If you're turning to putting a gun on the table, it's because you basically lost on the other fronts. And passing the law leaves a lot of dry powder, you know, times change. And so you can always, it changes the dynamics within countries. That's always an important part. But thank you, this was a terrific conversation. Thank you so much. And thank you for coming all the way from far away. And it was a very important message.